let us get started with the judicial system. We're going to talk about judicial processes at the state and at the federal level. And interestingly enough, I don't know if any of you realize it, but military courts are also part of the processes at the federal level. And I'll touch on those as well. Okay? That might be interesting. This is aiming too much at the ceiling. Let's stop that from happening. There we go. All right. So, the judicial system of the United States and our processes. There are two types of jurisdiction. We call the first one original jurisdiction, and the second one appellate jurisdiction. Now, original jurisdiction is the power that trial courts at the very basic level have to hear cases. So every time someone goes into a court and they go before a jury and a judge, they are in a court of original jurisdiction. Okay? The next one is the appellate level. After original jurisdiction and after the courts where the trials are heard, people essentially, often, well, almost every time, want a second opinion. Because somebody is always unhappy with the result. Can you imagine? I can. Somebody who says, no, we're not going to let you do this, or no, this person is not responsible, they're going to want to appeal. That is what appellate jurisdiction is for. It's the power at that level to review original jurisdiction courts' decisions to determine whether they erred in their decisions and whether or not there was anything that the judge did that was wrong, too. Most appellate jurisdiction comes from the fact that the judge may have made an error, not the juries. We'll talk about jury error when we get up to the process, okay? We also have in personam jurisdiction and subject matter jurisdiction. Now, in personam jurisdiction is the jurisdiction that a court has over the person. It's whether or not they have the power over that person to make a decision and carry out what that person needs or is going to have taken away from them. Subject matter jurisdiction is the power to hear certain kinds of cases. Not every court hears property cases. Not every court hears juvenile cases. Not every court hears probate and estate cases. So the question is, do we have it in the right place, and do we have the right people that we know to participate in those cases? That is where we have in personam jurisdiction and subject matter jurisdiction. Now, there can be some confusion when we talk about the power to hear certain cases, because if we say this court doesn't have the authority to hear probate cases or cases about the wealth that someone leaves behind when they die, where do we go? The same thing happens when we have a subject that a state court would hear, but it's actually a federal matter. What happens then? Well, one court has to dismiss it, and then the party who is complaining must refile it in the other court. We'll talk about what subject matter jurisdiction federal courts have exclusively. Exclusively. This means that when we go to file a case and we have one of these, then we have the right court if we are filing federally. If we don't have the right court, then we have to make sure that we do. Exclusive federal jurisdiction, that means only the federal courts have jurisdiction, are admiralty cases. When I say admiralty, what do you think of? Admiral, which is on the
water?
Yes, good. Admiralty cases deal with things that are within the jurisdiction of the United States, within its borders, going out to sea, 12 miles. Okay? We have jurisdiction out to 12 miles. Federal military cases. Federal military cases are those that are within the United States Coast Guard, Army, Navy, Air Force, Marines. Did I forget anybody? Army, Navy, Air Force,
Air Force.
I said Air Force. Oh, Air Force. And now, the Space Force. You know we have a new Space Force? It's a real branch of the military with a real 4-star general commanding. They just had the command assignment day before yesterday. If you notice up here, I included active duty cases for the National Guard, but that means that the National Guard does not have jurisdiction, or the federal government does not have jurisdiction over the National Guard when they're not on active federal duty. Yeah.
Are they not one of the branches, the National Guard?
They are, but they are under the command of the governor of a state. And the only time that they become federalized is by order of the President of the United States and the Secretary of Defense. That's when the federal government would take federal jurisdiction. Bankruptcy. Bankruptcy is the exclusive province of the federal government. And it's a very practical reason why it's exclusive to the federal government. What if people had to file for bankruptcy in 50 different states in order to make sure that all of their creditors were informed and were part of the process? That would be expensive. It would get to be almost ridiculous, and a case would last forever. So people file once in federal bankruptcy court, and it covers the entire United States. Federal criminal prosecutions. If it's a federal crime, it is a federal criminal prosecution, and they have exclusive jurisdiction. Cases in which one state sues another state. We had that happen here. It sounds kind of weird, but Tennessee was sued by Georgia because of the border. You remember what it was about the border that Georgia wanted? Anybody know? That was a good start. Anybody know what Georgia wanted?
Was it a water source?
It was.
Oh,
It was. They wanted part of Nickajack Lake, so that they could pull water out of the reservoir that Tennessee built and has exclusive jurisdiction over, combined with the Corps of Engineers. That's really good. That's really good. Claims against the United States. That's where there's some sort of claim made against the United States government, and it goes to court. Federal patent, trademark, and copyright claims. Does anybody know why patents, trademarks, and copyrights are exclusive federal jurisdiction? Go ahead.
You can take somebody to court, but they take your life over as far as that goes.
That's what they do. And the reason they do that at the federal level is the same reason that we do it, because of bankruptcy. It would just get too broad to handle if we didn't combine it all into one office. And people would lose control of who was creating what invention and where it was being filed. So it's all done at the federal level. And then we have other claims involving federal statutes that specify exclusive federal jurisdiction. They go one by one. And you have to read the status of the statute in order to know what one that is. Concurrent federal and state jurisdiction occurs in federal question cases. Somebody can sue someone else on a federal law even though they do it in state court. If the state court believes that it doesn't understand the law well enough, it will remove itself and send it to the district court. There's no penalty involved here when that happens. They just do it. They just step aside. Okay? And that's for concurrent state and federal jurisdiction. Sometimes something is sued for in state court that ought to be in federal court, like one of those topics we just went through. When an attorney finds out that it should be in federal court and it's a disadvantage to be in the state court, even though it is stated, what they'll do is they'll move for removal or dismissal of the case, and then the state court will give them permission to be dismissed without prejudice, which means they can file it again somewhere else, and then they take it to the federal court. For instance, say there's an automobile accident with a big truck and it causes $100,000 in damage and the person sues in state court. Well, when we were talking about constitutional law, I brought up the fact that at $75,000, you can sue in federal court. And federal courts tend to be a lot more easy to navigate when there is something like a personal property loss or a business property loss. So someone would want to dismiss that case and then take it up to the federal level, okay? Diversity of citizenship cases. Diversity of citizenship is a very difficult concept. Diversity of citizenship means that none of the parties that are suing, none of the parties that are defendants can be from the same state. It kind of sounds like interstate commerce, doesn't it?
Mm-hmm.
Where you have to cross a state line in order to get federal jurisdiction. And that's correct. In order to cross state lines, you do have to have federal jurisdiction in a case, but you don't have to. It can either be filed in one state where one person lives in state court, or in the state court of where the other person lives. But if it's too complicated to do that, you can sue in federal court because they're citizens of two different states. That's diversity of citizenship. It can become a very complicated question. All cases not falling under the exclusive jurisdiction of the federal government, including National Guard, military, non-federal duty cases, stay in the state courts. They stay in the state courts. So if the National Guard isn't federalized, it's a state matter exclusively. And the National Guards are actually, while they are military forces that can be used by the federal government and are often mobilized by the federal government, they are actually under the command of the governor. So now let's talk about the federal court system for just a couple of minutes. The United States Supreme Court is the Supreme Court of the land. That's over everything. That court will give decisions on every matter that's necessary to be brought before it, or every other one to which it is appealed. We have intermediate courts of appeal, and then we have federal trial courts. When somebody starts in the federal trial courts, which are the courts of first instance, and they don't like the result, they can appeal it to the intermediate court, which is the Court of Appeal. And here in the federal trial system, we call them circuit courts. They're called circuit courts because there was a time when there were so few federal judges that they actually rode from district to district on horseback in a circuit. And they just kept going around that circuit until they had hit all of the points where they were supposed to hear a trial. And then they would start all over again. So it was called a Federal Circuit Court of Appeal. In the military, we have the Court of Military Appeals. They are analogous to the courts of appeals or the circuit courts of appeals. The courts martial are equivalent to the federal trial courts or the courts of first instance. So the court martial takes the place of the civilian trial court. Anybody here have any relatives or anything in the military? Okay, you might hear about this at some point on the news or from them or from somebody. There was just a military verdict. There was a woman who was in the Air Force and worked for the National Security Agency. And she leaked information about the Russia investigation into the public view. That was not legal because she was part of the National Security Agency, the NSA. They arrested her and tried her for conduct unbecoming a member of the United States Armed Forces in court-martial and treason as a member of the United States military. The statutes are different. The civilian and the military statutes are different. And some people are saying she should not have been tried that way. I am one of them. I do not believe that she should have been tried. Specifically after we started finding out additional information about what's been going on with the difference between Russia trying to hack our civilian election systems and that sort of thing. There were mitigating circumstances, and she thought she was doing the right thing.
She was doing it for us?
She was doing it for us, but the military says you can't do that, and she was part of the Air Force. So they tried her in court-martial. State court systems are parallel to the federal court system. We have state trial courts. We have courts of appeal, which are intermediate between the trial courts, or the courts of first instance, and the Supreme Courts. So it runs trial court to court of appeal to Supreme Court. The Supreme Court in each state has the final say on state laws. The military has a parallel court system. They operate under their own set of statutes called the Uniform Code of Military Justice, or the UCMJ for short. The UCMJ has several types of prosecution available. The first is two types of non-judicial punishment called the Article 15. Article 15s are administered either by the commanding officer of a unit or the commanding officer of a battalion. The company commander has a lesser number of options insofar as punishment goes. So it's really for very minor infractions. They can give them extra duty, take some of their pay, and knock them down a rank. That's it. Once the report of that Article 15 goes into their military personnel jacket and they leave the unit, all of those Article 15s or any Article 15s they've accumulated are taken out, torn up, and thrown away, and they do not affect the rest of their military career. The battalion Article 15, administered by the battalion commander, on the other hand, is a permanent document and stays in the field jacket of the individual who has been adjudicated under the Article 15. Now, this is the commander's prerogative. It's a battalion or a company commander's prerogative to administer these. The punishments at the battalion level, which is a bigger unit, is much higher, much heavier, and can include being broken more than 2 or more ranks, not just one like at the company. I used to know people in the military when I was in the military that almost could have had zippers on their stripes, on their sleeve, because they were up and down, because they do something, they get caught for DUI, and they go before the company commander, and he administer non-judicial punishment under Article 15, and they take a stripe off. Well, then they'd earn it back, and then something else would happen. And eventually, they were no longer members of the military. If the individual refuses the non-judicial punishment, Article 15, the case is referred to an Article 32 investigation. Article 32 is like the equivalent of a civilian grand jury. Except, there's only one person who's looking at the evidence. He's a senior officer, and he or she has been through it all. They know what they're looking at. They know what the infraction looks like. They know what they should do. It's different than our civilian system, because our civilian grand juries only hear from the prosecutor. That's it. They only hear one side of the story. In the military, under the Uniform Code of Military Justice, the defense can also present information or evidence to the hearing officer in an attempt to have the case dismissed. And it does happen. It happens all the time, where it's a disinterested officer from some other unit somewhere else gets these cases, looks at all the evidence, looks at the Uniform Code of Military Justice, and says, I'm not going to court-martial this individual. Send it back to the company or the battalion commander. If they want to give him an Article 15, that's fine. Otherwise, I'm dismissing these charges right now. And they write up their report, and that's what happens. So that investigator is the one who decides if it will or if it will not go to trial. And the trial there is called a court-martial. You've heard that, I'm sure, somewhere. After the conclusion of the Article 32 investigation and the court-martial has been assigned, is assigned to a special military judge. Military judges are just like regular judges. They wear black judicial robes. They sit at a desk in a regular courtroom. They look just like a judge, but when they take that black robe off, they're at least wearing colonel's insignia on their shoulders. They're very, very senior officers. The jury is composed of 6 to 8 officers. These are the peers or the individuals that are supposed to know this. I was trained in the Uniform Code of Military Justice when I was a senior in college as a member of the military, because at some point I was going to have to know what was going on there. And I did. I sat on 2 court-martials as a lieutenant. Trial procedure is exactly the same as in a civilian world. Exactly the same. Appeal, however, when they appeal it, it's appealed to the commanding officer of the unit in which the individual is assigned. So if the individual is assigned to a unit which has a general as a commanding officer, it will be that general that decides the appeal, not an appellate court. If the judge, who is the colonel, signs off on it, it's appealed, and the appeal decides to be appealed, which it can be appealed, it's appealed to It's appealed to the United States Military Court of Justice, which is in Washington, D.C. The Military Court of Justice has 2 Supreme Court justices which sit on it, and they're the ones that make the final decision jointly. In civilian life, back to civilian life, the real world for us, there's such a thing called requirements for litigation. The first is standing. Standing means, did they or did they not have a part of this case? If someone steals a pink plastic flamingo off of the lawn and the person who has it stolen from them wants to sue to get the value back, it had to have been their pink plastic flamingo. The neighbor across the street can't sue them. It wasn't theirs. It has to be the person whose flamingo was stolen. I know that's silly, but it makes a good example. A case or controversy must be judicial. That means there must be some sort of a very real controversy, not just something that's made up, or something that is not written into law or isn't part of public policy. It has to be a real controversy. And then it has to be right. It has to be right. What do you think ripeness would mean? The right time. Sometimes cases are filed in anticipation of something happening. When a case is filed in anticipation of, it may not be right. It may not have come for its time to be decided. Only when it actually happens is it right. Okay? Steps in pretrial litigation. The first is informal negotiations. Judges are always saying, please try and settle this. It's so much less expensive for you and so much less time consuming for the court. Try and settle it. So attorneys almost always try to settle things between themselves, unless a client does not want them to. Once there are informal negotiations and they have collapsed, we have what is called a pleading stage. Now, pleadings are when someone files a complaint. The complaint says, this person did this thing and it wasn't supposed to happen. Now, for example, the person that stole the pink plastic flamingo. I'm suing to get my flamingo back or the value of that flamingo so I can replace that flamingo on my front lawn. That's the complaint. It's written and it's filed by the person who is called the plaintiff afterward. The service of process comes from the serving of the complaint on the person who is being sued. We call them the defendant. Once this is served, they are a defendant in the case. The defendant then will file a response to that is referred to as an answer. They answer the complaint. And every complaint is set out into paragraphs and statements numbered throughout the complaint. The defendant's answer should echo each individual paragraph or each individual point saying, I admit that this is correct, I deny that this is correct, or I cannot discuss the truth or falsity of that particular item because I have no knowledge. That is what the answer is made up of. It doesn't have to go into any length or try and present any arguments. It just has to inform the plaintiff where they are with this particular suit. Sometimes the defendant will say, okay, yeah, I admit every one of the allegations included in this complaint. And then they go back into informal negotiation to try and resolve it. If they do not, then they start what we call pretrial motions. And pretrial motions are the kinds of motions which ask for witnesses lists, asks for an individual's version of something. It has depositions. You know what a deposition is? Some do, some don't. A deposition is when the attorneys for the two parties get together. There's a court reporter, and the attorneys ask individual witnesses that were listed on the witness list that they got from discovery questions about who and when and what and how the pink plastic flamingo was stolen. They may even present expert witnesses who are experts in the theft of pink plastic flamingos. Yeah.
Is this when they do the lady, like the person types everything that's being said?
Yes.
They're not a witness.
That's a court reporter. And that court reporter takes down everything that is being said to make sure that they can use that at trial later. Because the statements they make in the deposition are under oath. They are sworn to tell the truth, the whole truth, and nothing but the truth. And they have to. If they say something wrong, the deposition can be used against them because it is admitted as a document of evidence in trial. They can use it to show that they lied in court. And then the judge is like, you said this back in the deposition, you're saying this now, which is true. And that discredits a witness when you do something like that. If you discredit a witness, then the jury can't tell whether they're telling the truth or not, and they may just decide to disregard their testimony completely. So we go through discovery, and we get all of our witnesses together and everybody, and then we go to a pretrial conference. Now, the pretrial conference is held with the judge that is going to hear the trial. And that pretrial conference sets up the time, the place, the manner, who's doing what, how it's going to be done, and all of the particulars. In what order the witnesses are going to be introduced. Just maybe. They should have the witnesses lined up in order, ready to go when they go into the pretrial conference. Because it just takes too much time, and all these trials take up the judge's time. Then we have jury selection. It works the same whether we're in criminal or in a military court martial. It's called voir dire. V-O-I-R-E-D-I-R-E. Or V-O-I-R-D-I-R-E. And here's the way it works. And I've been through this myself, so I can give you all the particulars. Yeah. V-O-I-R-D-I-R-E. It's called voir dire. You get a notice, and you get a notice from the state that says you will report for jury duty at a certain time and place from the court clerk. That document tells you you have to be there, and you're to report into the district assistant court clerks when you arrive. So you go in, and the clerks are behind the desk, and you sign in. And they may give you a questionnaire, and they give you a number, and you wear your number, a little sticker on your shirt, and you go in and you sit down and you fill out your questionnaire. It asks you all sorts of questions that the attorneys for the trial that you are going to possibly be called into have written to see if you have any predisposed ideas about that subject matter. The one that I was in, they were asking about automobile accidents and truck accidents and people dying as a result of truck accidents, and this, that, just all kinds of stuff like that. And then they practically ask for your resume. And you have to put that down. And they say, have you ever had any experience at court before? Have you ever been on a jury before? Have you ever done this with law before? And they ask all sorts of questions. You write it out and you turn it in, and then you sit there. We sat there for 6 hours after we finished filling these things out. And the attorneys upstairs went through all of these questionnaires with the judge, and then gave a judge a list of the people they wanted to call first by number. So we went upstairs, and we were taken into the courtroom, and we all sat in those benches back in the courtroom. And they started calling numbers. They called 16 people up. That would be 12 jurors and 4 alternates. And they asked them all questions. They started asking them, would you be prejudiced against the defendant if you knew that a child died in this accident? Some people said yes. Some people said no. Some people said we'd have to hear the facts. And this went on through all 16 jurors. They asked the same questions over and over and over again. And at the end of the discussion with the first 16, the attorneys take slips of paper up to the judge of who they want to dismiss from the jury. Now, either side can dismiss as many jurors as it wants, if there is a reason. We call that for cause. For cause. Dismiss them for cause. So they can go through that as many times as they need to. And there must have been 100 of us in the courtroom. And every time they dismissed people, they'd bring the new ones up and they'd start the questioning of them all over again. And they asked them more questions again and again and again. And every time mine came to the top, and I knew it was mine, not because our names were written on it or anything. Every time mine came to the top where they were going to ask somebody to go sit on the jury, the judge would look up. He knew what it was, and he'd just take it and put it right back underneath the pile. Mm-hmm. This was from Chattanooga. This was a trial. It was from Chattanooga, and it was a change of venue. A change of venue means that they don't think they can get a fair trial where the court of initial jurisdiction sat because it was too widely publicized, and everybody knew what had happened. And so they finally got everybody questioned, and they had a jury, and the judge finally said, "Okay, there's a jury." And one of the defense attorneys turned to their assistant right next to them and said, he pointed to me and said, "He was never going to get called." And the assistant looked at him and said, "Why?" He said, "He's just like." Do you know who Bull is? You ever watch NCIS on Tuesday night? Right after that is a show about a trial consultant who knows how to pick out juries and how they're going to react to certain types of stimuli from a individual who's taking the stand and a certain defendant, and he can pick out who he wants on that jury and not on that jury, and he knows how to direct his attorney to manipulate those jurors. I used to do that. I still do that. I'm a trial consultant. I can not only, I'm not only an attorney, but I can also help other attorneys choose juries. And I had to put that down on my questionnaire. And that judge from Chattanooga suddenly realized he knew me and that I'd worked down there. And just
just kept putting it back underneath. Just kept putting it underneath.
It turns out, and here's why juries are questioned so carefully during jury selection. Okay, it's because this particular jury, in this case, was seated because the individual had been driving an 18-wheel truck, had hit 4 cars, weaving back and forth in various lanes, killed 10 people, and 4 of them were children. He was on methamphetamine. So nothing we could do in Chattanooga would have brought him a fair trial. And they're hoping by a change of venue, we could bring him up and have a fair trial. I thought it was very interesting. We start talking about going to opening statements. During voir dire, the tables and the arrangement of the courtroom are such that the judge is up in front. The court reporters sit right underneath him, so they can hear them, they can hear the attorneys, and they can hear the witnesses that sit right next to the judge. During the voir dire in this particular case, they had rearranged the tables so that you had the judge, then you had set back even with, so it almost made an L with the prosecution table, but maybe a couple of feet away, the defense table. And they had the defense attorney, they had the assistant defense attorney, they had the defendant, and then they had a couple of other like paralegals or legal assistants sitting there. But you couldn't see the defendant from the jury box because he was being covered up by some of these other people. You know why? He wouldn't have gotten a fair trial in Davidson County either, because he was manacled hand and foot, and they were tied to his belt, so he could not move. He was a flight risk, and he was a danger himself and others. But they didn't want the jury to see that. So you'll see that during jury selection, if you ever watch Roll and you want to see how that's done, turn that on. It's at 8 o'clock on Tuesday nights. It can be very interesting. They're in reruns right now, but I don't think any of you probably have seen them. But it's excellent. I don't like attorney and trial shows generally, but this one I can really get with. You know, it's really a good show. Really well done. Examination of witnesses comes after opening statements. During opening statements, the first person to speak is the prosecution. And then the prosecution has the opportunity to sit down and listen to what the defense is going to do in their case. Well, if the defense is used to doing this a lot, they're going to say, Your Honor, I defer my opening statement until the beginning of my case in chief. Which means they don't have to say anything until after the prosecution's put on their entire case. Because they're hoping that at the beginning of their opening statement, as a defense, they can make a motion to the judge to dismiss for lack of sufficient probable cause. Lack of sufficient evidence. Something wrong with the law, which would cause the case to be dismissed or to be declared a mistrial, which would cause it to be tried a second time. Or everybody would be gone, okay? So, before examination of witnesses, the prosecution starts its case. Then it brings up its witnesses, and they present their evidence. And the defense has the opportunity to cross-examine every witness. So it goes direct examination, cross-examination, redirect, because the prosecution gets to get up and ask them questions about what the defense just cross-examined them on. But it's limited to what they just asked questions about. And then the defense gets up for recross And then finally, somebody's going to get tired and say, I have no further questions of this witness, and everybody sits down. But it goes direct, cross, redirect, recross, redirect, recross, until somebody's tired and wants to go home. That goes through every single witness that is going to be presented. Then, the defense, who has now deferred their case and their opening statement to the beginning of their case, gets up and presents their opening statement. And then this starts all over again. They ask all of their witnesses what the defense needs to put out. The prosecution has a chance to cross-examine. And it goes back and forth until everybody's asked all the questions and they're tired and they want to go home. Or they've gotten to the truth of the matter. It's more like it. Then they present closing arguments. The prosecution starts. It presents its closing argument. Then the defense gets up and makes its closing argument. And then the prosecution gets another bite out of that apple. They get up and talk about what was wrong with what the defense just said. So they get to make two closing arguments. Once that's done, it goes to the judge. And the judge will turn to the prosecution and defense and say, send me within 24 hours your request for jury instructions. Jury instructions are what each think the jury should do. Okay? So they get those, they get them all written down. The next day, the jury is assembled. And the judge reads the jury instructions he has selected based on the law and the trial, reads them to the jury, and then the jury leaves and goes out and begins to deliberate. Okay? Now, the jury will deliberate and come back with findings. They will find either for the plaintiff in a civil case or the defendant in a civil case, for the prosecution or the defense in a criminal case. If that is the case, once that's all done, I say case multiple times in the same sentence, and I can do that really well. Somebody is going to stand up and move the judge for a judgment in accordance with the verdict. That's generally the person who just won. Because you need a motion to move the verdict forward. And that person will say, okay, I move that the findings of the jury be accepted in the court, in this court, etc., etc. Then the other side, who didn't win, will get up and say, Your Honor, I move for a judgment notwithstanding the verdict. It's called a JNOV. Judgment notwithstanding the verdict. And the reason it doesn't have the English letters for the English words is because it's all Latin and nobody ever uses that Latin. So a judgment notwithstanding the verdict means they want the judge to overturn what the jury just did. Okay? And if that doesn't work, then the one who lost the trial will probably get up and move for a new trial. And they will set out their reasons. Generally, a motion for a new trial is based upon judicial error, not what the jury did. Based on judicial error, and it's usually in the jury instructions, the way they were handled, or the way the judge did something, accepting witnesses, accepting witness statements. He he allowed some objections that he shouldn't have, he didn't allow other things in that he should have, that sort of thing. And if the judge knows what he did and did not do correctly, he will either accept or refuse that motion for a new trial. So it can be rejected fairly quickly. So then the trial is over. In a criminal trial, it starts with a coercive environment, and we look at Miranda. When the individual is in police custody, okay, or in a coercive environment. Now that does include questioning on the scene if the authorities believe that that individual may have perpetrated the crime. And coercive means that there is a pressure from the authorities to make the individual uncomfortable enough to want to talk. Police custody is anytime they're in the presence of police interrogators, they have to be read their Miranda rights. Where in the constitutional section did we discuss Miranda rights? Under what amendment? Somebody hold up your hand. That's the amendment. That's the amendment number. What is it? Fifth Amendment. Good job. We're right on it now. So the Fifth Amendment is where we find the Miranda. And it's in the presence of police interrogators. That is not only in the interrogation room, that is also when they are being questioned outside a police cruiser or inside a police cruiser or anywhere else that there are police present. At a pre-interrogation lineup, the Miranda rights have to be read. I have acted as an attorney at a pre-interrogation lineup where the witness comes in to identify the person they believe perpetrated the crime. Okay? But that involves a degree of coercion because the person can get nervous and start standing out. So they have to be allowed an attorney. The attorney does not have to be their trial attorney. It doesn't have to be somebody that's going to represent them the rest of the way through the trial or at any part of the trial. It just has to be an attorney that will be there to assure that their rights are accorded them. I have done that. I have just been standing outside the police precinct talking with somebody, and the desk sergeant comes running out and says, "Can you come in and observe a lineup and ensure that the defendant's rights are maintained?" Well, yes, I go in, I stand there, and I say, "Are you going to read my client's rights?" And they say, "Yes, we will now read him his rights." And they take out the card and read them their rights. Then they become part of the lineup, and then they go into that little room with the one-way glass, and they stand there. And the individual who is the witness attempts to find the person they believe was the perpetrator of the crime. Sometimes that works, and sometimes it doesn't.
So how do they pick who goes in, gets in the lineup?
It's actually done randomly.
How?
Take my applied statistics course,
Okay.
and I'll show you how random samples are created.
So they don't like go off of what the person described them as or anything?
Well, what they do is they find a whole bunch of people that fit under the general description. You'd be surprised at how many of those people are just coming off the street. They just walk in, they're somebody's relatives, or just, they say, "Can you participate in this?" And they agree to do it.
So it's not necessarily somebody that's in jail?
No,
Do they get any compensation?
no, they just do it as a favor. There might be donuts in the break room. I don't know.
Oh, if you can be like, oh, yeah, he looks like a lawyer.
I tell you what, there was a lineup that I was witnessing where the individual who was the witness actually did pick out the wrong person. Now, that doesn't mean it's over. What it means is that what they do next is they do a photo lineup. And instead of having the individual who may have witnessed it, they have the victim try and pick the individual out of a photo lineup. It works the same way. And they have just random photographs. They're all the same size and the same shape with everything. And they could be famous actors, they could be not very well-known actors.
What would make somebody just want to be like, yeah, I'll go stand on the lineup, and then they accidentally.
They're sitting there. There's donuts in the break room. I mean, I don't know. What made me go in as an attorney that's not being compensated and just listen to somebody's get read their rights and make sure that they have a fair line.
Because if things went wrong, you weren't going to jail?
Because if things went bad, I didn't want it on my conscience that I could have stopped it. And that's why people do the lineups, because they know that if the person is not close enough match, then he shouldn't be dragged off the street. So they do it. At the time of arrest, the lineups and the arrest and the interrogation don't always happen at the same time. Sometimes an individual will be released and told they're just a person of interest, and you can go home. And later they get a warrant and go out and they make the arrest. Well, when they make the arrest, wherever they make the arrest, at the time of the arrest, they read them their rights. So now this person may have had their rights read 1, 2, 3 times already. Then, when they're brought before the judge to be arraigned, that would be somewhere in here. When they're arraigned and booked, they are read their rights again. And then during trial, before the trial begins, in a little room off to the side where the defendants are kept, they read them their rights again. Now, what's the practical reason they would want to read them their rights before they go into trial?
In case they say something.
Oh, that's so right. That is so correct. I have seen, and I've been sitting as an observer in trials, and the defendant just cannot keep quiet. And they get up and they prejudice their own trial, and it either convicts them or it gets them declared a mistrial and they have to go through it again, or it gets them thrown out of the courtroom, or it gets them put in restraints or something, in order to keep them from prejudicing the jury that was just selected so they get a fair trial. You can't have a fair hearing if the defendant keeps jumping up and yelling stuff. But I've seen it happen. And then, after the trial, we have the sentencing phase. And before sentencing is carried out, that is, before they take them into the jail, before they take them, if the crime is serious enough to involve execution, before they take them from their cell into the death house, they are read their rights again. And then they carry out the sentence. Whether it's being locked into a confinement facility or it is being strapped to the table for lethal injection. Yes?
How long can all of this last?
How long can that last? How long can a trial last? Oh, the term. I think we may have talked about this a little bit when we were working on constitutional law with the 8th Amendment. How speedy is a speedy trial? It's however long it takes to be fair so that the prosecution gets all of its information out and the defense has the opportunity to absorb and defend that information.
But can't you
And
get
they're
like
playing.
time served?
Yes, sometimes they do. depending on the type of crime that the individual committed, they can have time served applied against their final sentence. So yes, the answer to that is yes, they can.
Sentence and you were in trial for 3 years, you could possibly get all that like for it.
Yes. Yes.
Why would they read them their rights before they put them under lethal injection if they're already gonna die?
I'm going to answer that because this has actually happened. They are allowed to make a final statement before they lower the blinds on the death chamber. They said, no, it isn't too late for who?
For the person,
The person who
it's not too late. Because what if they're like, oh, I didn't do it, and I have
The families of the victims are watching, yes. It's not too late for them. What can happen is that the individual will implicate someone who had nothing to do with it. And so they read them their rights so that they know that what they say can be used against the other person, because it's called a dying declaration. This person has nothing to lose if they want that person dead.
So like, okay, so you got to go and leave and make and you're like, oh, so-and-so did it. Then, like, what?
They also cut off the microphone if that stuff starts to happen. The extraction team knows pretty much what's going to happen.
What do you think of that?
I do not approve.
You don't approve of like them being able to repair the rights?
I approve of their rights.
The death.
I approve of it's the death penalty itself.
Yeah.
So how do you think you should do it?
Life. So life in solitary confinement.
They gonna eventually get other people.
Okay, that's my question, right? Okay, you say, oh, he did it, then so are they gonna start investigating that person and you still gonna die? Or are they gonna?
At this point, they do. They don't pause it.
You won't die.
They already have the jury's verdict.
So then what's the point of reading them their rights though? Like, it just.
It's due process. Right now, there's a trend in the Supreme Court that a coherent alibi has to be established at the time of the arrest in order for it to make any sense to use it at trial. Now, this is a trend. Now, where does that trend come from? It comes from the United Kingdom. In Great Britain, they require that an alibi be stated at the time a person is being arrested, or they can't use it at trial at all. They can't even bring it up.
Is that why, like, for those TV shows, when they're arresting people, they're like, where were you?
Yes. If it's a British television show and the British police are arresting someone, they say, where were you? What were you doing? You must tell us right now. The reason they have to tell them right now, well, there are two reasons. One, if a person is being told right now, they're rarely not going to tell them exactly anything but the truth because they don't have time to think about it. And where the mess comes in with are they telling the truth or not, or who do we believe or how, is when people have a lot of time to think about what they're going to say in between, and they talk to other folks, and just all kinds of things. So they want the alibi right away. And that's the way it is in Great Britain. It's not the way it is here in the United States, but it's starting to move that direction. So here are Miranda rights. You have the right to remain silent. What you say will be used against you in a court of law. You can consult an attorney and have an attorney present during questioning. If you can't afford an attorney, one is going to be appointed before questioning begins. If you do not have an attorney available, you have the right to remain silent until you get one. And they ask them, okay, so do you understand exactly what I have just said? Now, This is the exact phraseology of that particular card that they are read when they are read their rights. This came off of the card I used to carry when I was a officer in the United States Army working with the military police and the criminal investigation division, which are the sort of like the MI5 of the military. Yeah.
If you, for the last question, you said, are you willing to answer any question without your attorney? You say no.
Then it stops. Your attorney, it has to be present.
So what about the question of where were you?
Was it a coercive environment? If they're asking for an alibi, if they're asking for evidence, and they've already asked for an attorney, that gets thrown out. We're then dealing with the Sixth Amendment, the fruit of the poisonous tree. Okay? So that's what happens. We have something back there? Okay. Criminal procedure. Remember we talked about procedural due process. Things have to go in a certain order. There has to be an arrest. It has to be made by a civilian police authority. It cannot be made by a member of the military. We have separate legal systems. The military takes care of the military and civilians take care of the civilians. That's why as an officer in the United States military, I was not able to arrest a civilian.
But we can do a citizen's arrest, right?
There is still such a thing, and under some conditions, in California, I know that property violations, such as a minor trespass violation, requires a citizen's arrest. But the citizen's arrest has to be made with the presence of a police officer. Because if it is not done right, it gets thrown out, and it's the fruit of the poisonous tree. All over
How do
again.
you make a citizen's arrest in the presence of a police officer? I thought those would be like.
He tells you word
You
for
gotta call them.
word what you're supposed to do. You call them, you call the non-emergency number, they come out, you tell them what's going on. He says that would require a citizen's arrest. He says, I will stand with you. I will tell you, if you want to do that, I will tell you exactly what you are supposed to say, you're supposed to do, where you're supposed to stand, how you're supposed to look, just everything. And they walk you right through it. It requires a warrant for an arrest if the arrest is to be made after the incident. So if the individual who's a person of interest is let go to go home, we'll say, then after that, they have to go to a judge who is a completely disinterested judge. That means he'll never have any more to do with this case. And he issues the warrant, and they go out to the person's house, which is the only way you can get into somebody's house who's committed a crime, is with a warrant. And you go out and you make the arrest out there, and they're read their rights, and they're brought in.
It's a certain judge. You have to go to or
A certain one.
judge.
A certain judge is a judge that's no longer going to have anything to do with it. Here in Davidson County, there is a municipal court judge, which all he does is book individuals that are brought in by the police and issue warrants. Well, that's his only job. He does not hear cases. And so these people are allowed to go to him to get the arrest warrant. The other place you can go to get a warrant is from the district attorney, who then goes to a judge who is unaware of any circumstances except those things that are in the warrant. And then that judge writes down what the warrant was for and who it was and what the warrant number was. And when that comes up, when the chief judge is assigning cases to judges, he reviews that sheet, and that judge will not get that case. Before any warrant can be issued, there has to be probable cause. That means that there has to be a reasonable suspicion or a reasonable understanding that this must have happened. That's probable cause. Innocent behavior is insufficient even if there's time to obtain a warrant. Probable cause must be present even if there's no time to obtain a warrant. But there are emergency provisions. Now, what is innocent behavior? Innocent behavior, the example I use is one where I was standing over outside Satco, over in Vanderbilt, when I was teaching over at Vanderbilt. And the group of students, it was about 4 o'clock in the afternoon, and they had a late lunch or an early dinner or something, were going to study. They came out and they were carrying styrofoam cups with ice in them, and they were all happy. They were acting, they were singing and just dancing around, having a good time. Vanderbilt police officer pulls up to them, gets out of the car, and says, "I believe I have probable cause to arrest you for public intoxication." He says, "I need to inspect those cups." And they're like, what? Wait a minute. Oh, wait, there's my business law professor. You come over? And I came over, and he says, "Sir, what do you have to do anything with this?" I turned to the students and I said, "Do you want me to act as your attorney?" And they said, "Yes." I pulled out my attorney ID card, showed it to him, and I said, "I am the attorney for these individuals. What is your probable cause?" And he says, because there was water in the cups. And you could tell it was water. And so I said, "I think you should just release these people. If you're not going to release them, then I want you to cite them immediately and call Metro Police to have them arrested. And be assured that I will be here forever." And so he decided that he was going to be the better part of valor that day, and he released them, knowing that they were correct in their assumptions about innocent behavior. And about 30 minutes later, I was standing in front of the watch commander's desk. And the watch commander asked me if this is what I was looking for, and he handed me his badge. Back then, I wasn't anybody to mess with. Now I just take life nice and easy. Then, the same weekend, there was a group of individuals who came out of someplace in the same vicinity. And they were obviously falling down. And I was watching that too, I was there. And a police officer pulls up, gets out of his car, addresses the individuals and asks for identification, and they looked at me, and he looked at me, and I just went, and he cited them for public intoxication, took a couple of them into the hospital to dry them out. So you had the first innocent behavior, and the second was not innocent behavior. They were cited. Now, emergency provisions. Let me say a word about emergency provisions. If there's no time to obtain a warrant, probable cause must be present, and there are emergency provisions. Here's what emergency provisions are. Emergency provisions are when the evidence is likely to disappear, and you have the person right there, you're looking at them, you're looking at the evidence, but the evidence could disappear. Example that I know of is a friend of mine was an agent for the Tennessee Wildlife Authority, and he had been tracking an individual who was killing deer out of season and selling the meat. And he caught him with freshly killed deer. And he called for police backup, but the guy was already dragging it into his truck and was going to be gone out of there. And you know what happens to meat when you get ready to sell it. You have to cut it up. Well, if it was cut up, it couldn't be identified. Or he could chuck it in a river or in a ravine someplace and say, "I don't have anything." So, the Tennessee wildlife agent made the arrest right there himself. He had police power, so he made the arrest right there because the evidence was going to disappear. That's what I mean by emergency provisions. It has to be something that is so special that the evidence is destroyed. Warrants can only be issued if the arresting officer appears before that neutral and detached magistrate, so that's that judge. It's not going to have anything to do with the case again. Provides a description of the place to be searched and a description of the thing to be seized. A description of the thing to be searched, a house address, is sufficient. 123 Able Street, Poughkeepsie, New York. That is suitable for an arrest warrant. It is the address of the house and the property. And what are we searching for? We're searching for tropical parrot eggs, which are illegal because they're wild animals. They're not allowed, they're contraband. So we're looking for those. That's a description of what we're looking for. It's the place we're searching, and that's what we can do. We have to have probable cause. Somebody may have seen them going into the house with a carton of eggs, special padded cartons. But we would need all that together. Everything has to kind of come together at the same time. Then there's an arrest. They're booked before a judge. Generally, booking happens just right when they're taken the first time into the jail building. First appearance is when they appear before the judge the first time. Then they're indicted. They don't have to be indicted. They can get a bill of information from the district attorney if the jury won't return an indictment from the grand jury. And then an arraignment. Arraignment is when they actually appear before the judge for the first time and hear the charges against them. These are the actual charges. There was a guy who attacked and hit another man on a construction job downtown with a brick paver, with a stone paver. The guy was unconscious. He was bleeding very badly. His skull was fractured. They took him into Vanderbilt. He was alive, and then he was charged with aggravated assault, and because the rock was a weapon, and he died. So when he went to arraignment this morning, he was charged with murder, not just assault, murder. So at trial, and we're going to get into this when we talk about criminal defense and criminal prosecution, when we talk about criminal law later in the semester. So I'm just going to show you that we have to have jurisdiction over the person, and we have to have jurisdiction over the site where the crime was committed in order to try it in our county. Corpus delicti means there actually had to have been a crime, and that we have the right person. If we don't, and there was no crime, then everybody has to go. Burden of proof is always on the prosecution. It never shifts. The prosecution always has to prove their point. The level of proof required is different for different crimes. For misdemeanors, it's lesser. Normally we hear about beyond a reasonable doubt. Those are for felonies. Clear and convincing is often sufficient for a misdemeanor. The shift in burden of proof, there isn't one. I put that in just because I wanted to make that point. The burden of proof does not shift. It is always on the prosecution. Always. But there is some confusion over pleading affirmative defenses. Affirmative defenses are things like self-defense, insanity, intoxication, infancy. If a defense attorney decides to plead self-defense, well, there are certain elements that set up self-defense that have to be proven. The person had to have been in danger, it had to have been an immediate threat, there had to be bodily harm or injury involved or to be inflicted. The person must have had to have been in fear. You know, all those kind of things. They have to prove those. But it's the defense that puts on that case. it's the defense that examines their witness to make sure that all of these things actually happen. So that's where that confusion in the shifting of the burden of proof comes in. And you generally see that confusion on television because reporters are not trained to know what the burden of proof is, who bears it, and how it can change when an affirmative defense is involved. Okay, we'll talk about that more when we talk about criminal law. Then there's the right to confront witnesses. And I'll just simply say that every defendant has a right to confront witnesses. And the way they confront witnesses is through their attorneys. Sometimes if a person cannot behave themselves in the courtroom and they're yelling things out, which is why they read their rights, they have to be ushered out. But that doesn't mean that they're not present, in air quotes, in the courtroom, because their attorneys are still there. They're the ones that prepared the defense. So technically the defendant is still confronting the witnesses. Okay? It's a thing we call agency. The attorneys are the agents of the defendant, and they are the ones who pursue the defense. And we'll have a whole section on agency later on. Appellate procedure in civil litigation. Well, the party that lost at trial is usually unhappy because there's often money involved. They note the appellate court that they're bringing a case to them because they think there were mistakes. And they write up something called a notice of intent to appeal. That goes to the appellate court 10 days after trial ends. And all it has to be is just one sheet of paper that has the right heading on it, the case name, who the appellant is going to be, who the appellee is, and that they intend to appeal this case based on the merits or on error. And that's all it has to say. It's signed by the attorney, and it goes in. That's their notice to appeal. Generally, appeals are done not on facts from the jury. The jury usually gets things right. You got 12 people. I've learned never to underestimate the jury. What you need to do is pick your jury carefully so that the truth actually comes out. Because those people, those 12 people, are so smart. I mean, you put 12 minds together. Some will have street smarts. Some will have book smarts. Some will have mechanical ability. Some will know this, that, or the other thing. And they're thinking all this evidence through with all of their combined intelligence. So the only appeals that work when it's on facts from the jury amount to about 1% of the time. So where are the other 99%? Well, there's only one judge. And sometimes, you know, they say something wrong, they do something wrong, or they make a stupid face in court and make the defendant think they're being prejudiced against by the judge, or just all kinds of things can happen at a trial that are appealable. And most of the time comes from something the judge did or said. So there's your 99%. The appellant, the party that lost, files a brief within about 30 days. So it's been 40 days now since the trial, actually. The appellee, the party that won at trial, then has another 30 days to file a brief to say why the trial verdict was correct. So they're trying to get the appeal thrown out. There are between 2 and 9 judges assigned to discuss it. Generally, three judges. You have a chief judge and 2 associate judges, and they rotate. They're generally elected in the federal courts. They're appointed, and they rotate. Sometimes, if all 9 of the judges that are appointed in each district are sitting on this, we call that being an appeal in bank. ENBANC, in bank. The judges read all of the briefs. It's not like trial where they have witnesses attorneys get up and get to examine the witnesses all over again and defend, and that's, no. The judges read the briefs that the attorneys have filed, including any that are filed by individuals who are called friends of the court, who are trying to help the court make a decision. So amicus curiae means friends of the court. They don't directly, the friends of the court don't directly have anything to do with the case, but they have an interest. It's going to impact them somehow. The judge will allow them to file a brief. So the judges read all those briefs, all three appellate judges. Then the attorneys for the parties argue the case in hearings in which those three judges are present, or however many are going to hear it. Now, this can be scary. I put this note up. This is a note for myself. Describe how scary this can be for a young lawyer. It can be really scary because you have prepared a defense. You have prepared to speak to the facts and the errors of the case. And you get up and it's all in your mind. You've got it written down. You're allowed to have one folder, one manila folder that opens up right in front of you. And you write everything, all the salient points out on that particular folder. And you start speaking to the judges about your client and about how the appeal was made, how it was right or how it was wrong. And you get 30 seconds into that, they cut you off and start asking you questions about things about the case that you never even dreamed they would look at. But they have, because they've read the whole transcript, they've looked at all the briefs, they've consumed all of the information on all of the errors, and they know that case just as well as I did. And that can be really scary. You have to be fast on your feet, quick thinker. And the higher it goes, the scarier it gets. I've been before the United States Supreme Court twice. I had to face my arch nemesis, the Chief Justice Rehnquist, twice. Have anybody ever heard of him and his manner? To say he was brusque is putting it mildly. He could be downright brutal. He could be brutal. And he didn't make, he just stepped on it right now. Story time? Story time? I'm telling, this is the story right here. Because I'm telling you, after he got done with me the first time, I don't remember anything else. I answered the questions to the best of my ability. And we went on from there. The second time I went up in front of him. He looked down at me and he said, "Oh, you again." That made me feel really good, you know? And my only saving grace was my favorite justice who is still on the court. Our angel of the courts, Ruth Bader Ginsburg, stepped in and said, "This is the Honorable Mr. McNamee. He is from Ohio. I have a question." She cut him off. She's the only person I've ever heard cut him off. I survived that day, but I never went back again. Okay. So, that's it. That's the end. That's really the end of this. I will let you go. And we will talk about alternative dispute resolution the next time. Don't forget to come back. What time will you And let me turn this on. Do some trimming on this one.